Welcome to Chapter 6 in our SQE1 window series on criminal litigation. Today we are examining sentencing and appeal, two critical stages that complete the criminal justice journey. Sentencing is where punishment meets principles, where the court must balance multiple aims whilst respecting proportionality and fairness. Appeals provide the safety valve ensuring errors can be corrected and justice ultimately prevails. By the end of this session, we will understand how courts determine appropriate sentences and how defendants can challenge convictions or sentences they believe are wrong. So that's what we will try to understand. So sentencing follows either a guilty plea or a conviction after trial. It's the court's formal response to established criminal conduct, and it occurs in either the Crown Court or Magistrates Court, depending on where the case was tried. But sentencing is not simply about punishment. Courts must consider multiple statutory aims when determining sentence. These aims are punishment, protection of the public, deterrence of future offending, and rehabilitation of offender. Sometimes these aims pull in different directions, requiring careful balancing by the judge. So critically, the sentence must match the offense seriousness. The principle of proportionality is fundamental. You cannot impose a severe sentence for a minor offense, nor can you treat a serious offense too leniently. Beyond the main sentence, ancillary orders may follow. These include compensation order, costs, restraining orders, and other measures tailored to a particular case at that point. In exam, they can ask you, state 4 aims of sentencing, and you need to understand the answer is punishment, public protection, deterrence, and rehabilitation. All of it is aim of criminal justice system. So you need to kind of memorize all of them once you are sitting in your SQE exam or LLB exam. So the Sentencing Council issues definitive guidelines for most common offences. These guidelines are not mere suggestions. Courts must follow them unless doing so would be contrary to the interest of justice in the particular case. In certain cases, if you follow them, they go absurd. So each guideline sets an offense range based on the crime's seriousness. The range typically includes starting point for different culpability and harm levels, then allows adjustment for aggravating and mitigating factors. The purpose is promoting consistency across courts. Similar offending should attract similar sentences, regardless of which court or which judge hears the case. This consistency enhances public confidence in the criminal justice system. However, guidelines allow limited judicial discretion. Judges can depart from guidelines when the particular facts justify it, but they must explain their reasoning that why they departed. So in exam, they can ask when guidelines be departed from, when following the guidelines would be contrary to the interest of justice in specific case. Departure requires justification and reasoning and explanation by the judge. So the next thing is sentencing procedure after trial or plea. Let's talk through sentencing procedure step by step to understand what happens in the courtroom. First, if sentencing follows a trial conviction, the effects are already established through evidence heard during trial at that point. The court knows exactly what happened. Second, the prosecutor addresses the court. They outline the victim impact statement, how the crime affected the victim physically, emotionally, or financially. They also provide the defendant's previous conviction, if any exist. These convictions are relevant to assessing seriousness and determining sentence at that point. So third, the prosecutor seeks ancillary orders, costs against the defendant, compensation for the victim, and any other relevant orders. Fourth, the defense makes a plea in mitigation. This is an opportunity as defense counsel to they can advocate for the least severe sentence consistent with the justice. They highlight personal mitigation, remorse, like, steps taken towards rehabilitation, and any other factor suggesting a lower sentence is appropriate. If the court requests a pre-sentence report, PSR, that's called, the case must be adjourned. The probation service prepares this report assessing the defendant's risk and circumstances and recommending suitable sentences. In exam, they can ask what happens first at sentencing. The facts are established, then the prosecutor addresses on victim's impact and previous convictions before seeking cost and compensation. So that's what you need to keep in mind. Our favorite and exam favorite, Newton hearings. Like, sometimes a defendant pleads guilty but disputes the factual basis alleged by the prosecution. When this dispute would affect sentence significantly, the court holds Newton hearing, named after the case of Newton in 1983, not that Newton physicist, it's different. So let's identify the condition first. There has been a guilty plea. The defendant admits the offense. Second, specific facts are disputed. Perhaps the defendant admits assault but denies using a weapon. Third, the dispute would make a material difference to the sentence, and it's not like very small or trivial. So at a Newton hearing, evidence is called, witness testify, and they are cross-examined, and normal evidential rules apply on it. This is a mini trial on the disputed facts. Crucially, the prosecution bears the burden of proving the disputed facts beyond reasonable doubt. They are asserting the aggravating variant, so they must prove it, So if the prosecution succeeds in proving their variant, the defendant's guilty plea credit may be reduced. The court might view the dispute as including less genuine remorse or acceptance of responsibility. In exam, they can ask you who bears the burden in Newton hearing. It's prosecution. They must prove their version of disputed facts beyond reasonable doubt. That's what you need to keep in mind, and sometimes it appears in exam. So, Sentencing Code and Sentencing Hierarchy. Sentencing Act 2020 codifies sentencing law in England and Wales. This comprehensive statute consolidates previous legislations, making sentencing more accessible and coherent. It applies to both adult and offenders under 18, though with different provisions for youth offending. So, sentences exist in a hierarchy reflecting increasing severity. At the top is custody, immediate imprisonment or detention. That's the harsh one. Custody can also be suspended, meaning the defendant does not go to prison immediately but faces activation if they breach condition or commit further offences during the operational period. Next comes community sentences, court orders, and those court orders require the defendant to comply with specified requirement, or like unpaid work, curfews, or supervisions. And under that is financial orders, fines, and compensation. These punish through financial penalty and can compensate victims. And at the bottom of hierarchy are discharges, conditional or absolute. These represent the court's conclusion that no further punishment beyond the conviction itself is necessary. That's it. Conviction is done, but conviction in itself is a punishment, I believe. The person who is convicted is barred from many things in society. So in exam, they can also list the sentencing hierarchy from the most to least severe. So you need to understand custody is the severe, and then suspended custody, community order, fines or compensation, discharge, all of it is hierarchy of sentences. So the core sentencing principle is that sentences must be no more severe than the offense seriousness. But how do court assess seriousness? There are two limbs. There are two parts of the test, culpability and harm. Culpability means defendant's blameworthiness, their mental state and role. Harm means the actual or potential harm caused to victim, communities, or other interests. So higher culpability and higher harm, greater harm, combine to increase seriousness. Lower culpability and lesser harm reduces it. So aggravating factors increase seriousness. Previous convictions are statutory aggravating factors. They demonstrate the defendant has not learned from the past punishment and has returned to offending. Similarly, committing an offence whilst on bail for another offence is statutory aggravation once again. Beyond statutory aggravation, each offence guidelines list specific aggravating factors. For assault, these might include premeditation, use of weapon, or offending against vulnerable victims at that point, like if someone attacks like a disabled person. So mitigating factors work the opposite direction. They reduce seriousness within the guideline framework. They might include provocation, mental health issues, or remorse. So in exam, you need to understand what two limbs define seriousness. So you need to understand and memorize that is culpability and harm. The more culpability and harm, the more it is seriousness. So the next thing is, so let's talk about how courts measure culpability and harm. So culpability encompasses the defendant's mental state, intention, recklessness, knowledge, or negligence. Intention typically represents highest culpability. Planning and premeditation increase culpability further because they show deliberate choice rather than impulsive action. Most guidelines divide culpability into three categories: high, medium, and lower. High culpability involves intentional offending with planning. Medium involves recklessness or intention without significant planning. And lower culpability might involve negligence or impulsive action. So harm assessment focuses on the victim, the community, and the other affected interests. Physical injury, psychological trauma, financial loss, and property damage all constitute harm. Guidelines often categorize harm into levels, categories 1 through 4, with category 1 representing greatest harm. So guidelines then provide a starting point based on the culpability and harm combination. High culpability plus high harm attracts the highest starting point. Lower culpability plus lesser harm attracts the lowest. So after establishing the start point, adjust for personal mitigation factors about the defendant rather than the offense itself at that point. So in exam, they can ask which culpability level is highest: intentional, planned offending. Understanding these steps will help you categorize offenses correctly in your exam. So guilty plea and reduction. Defendant who pleads guilty receives sentence reduction as recognition that they have saved court time and resources, spared witnesses from testifying, and shown some acceptance of responsibility. This discount rewards early guilty pleas most generously. For example, a guilty plea at the first reasonable opportunity typically attracts 1/3 reduction. That's 33% of the sentence that would otherwise be imposed. Later pleas receive a progressively less credit. A guilty plea on the day of trial might attract only 10% reduction, 1/10 you can say it. So the principle is incentivizing early resolution rather than waiting until the last minute. However, Newton hearing can affect credit. If the defendant disputes facts unsuccessfully at a Newton hearing, the court might reduce the guilty plea credit because the dispute has caused delay and additional court time. The guilty plea guidelines set out the precise structure for calculating reduction based on timing. So courts must follow these guidelines unless it would be contrary to justice. In exam, they can ask like typical maximum discount and the minimum discount and when it happens. So you need to keep in mind both of these answers so it can appear in your. So, PSR reports, pre-sentence reports, are prepared by probation service and provide court with essential information about sentencing decisions. So, a PSR assesses the defendant's risk of reoffending and risk of causing serious harm. It explores the cause of offending, perhaps addiction, mental health issues, or social circumstances. It recommends suitable sentence options that might address these causes and reduce future offending risks. Importantly, court are not bound by PSR recommendation. The report is advisory and the court make the final sentencing decision. However, court take PSRs seriously because probation officers are expert in risk assessment and sentence management. So mitigation is the defense opportunity to argue for leniency. Effective mitigation covers both the offense and the defendant's personal circumstances. You might highlight that the offense was out of character, that the defendant shows genuine remorse, that they have taken steps towards rehabilitation, or that custody would have devastating consequences for dependent family members and all. So mitigation does not change the fact of the offense, but it provides context and presents the defendant as a whole person rather than simply an offender. So in exam, they can ask like name three PSR contents, that is risk management, causes of offending, and sentence recommendation. All of it is part of PSR. That's what you need to keep in mind, and purpose of PSR as well. So the next thing is custody threshold. Custody, and that can appear in exam. So custody represents the most severe sentence, so there are important threshold and limits governing when it can be imposed. So for some offenses, custody is mandatory, like murder. And murder carries a mandatory life sentence. The judge has no discretion. Other offenses have mandatory minimum sentence in specified circumstances. For discretionary custody, the court must satisfy the custody threshold. This means the offense is so serious that neither a fine alone nor a community sentence can be justified. This threshold protects against disproportionate use of imprisonment. Our prisons are full. So magistrate sentencing powers are limited compared to Crown Court. For a single either way offence, magistrate can impose maximum 6-month custody. For 2 or more either way offences, they can impose consecutive sentences up to 12 months aggregate. So the magistrate believe their powers are, if they believe that their powers are insufficient, they can commit the defendant to Crown Court for sentence after a guilty plea or conviction. This allows the Crown Court's higher power to be used at that point for sentencing. And in exam, they can state the custody threshold. At that point, you need to understand the offence must be so serious that neither a fine alone nor a community sentence can be justified. This threshold language appears directly in statute and must be satisfied before custody can be imposed. So the next is totality and concurrent versus consecutive sentences. So when a defendant is sentenced for multiple offences, the court must consider totality, ensuring the overall sentence remains proportionate and just. Concurrent sentences run simultaneously. If a defendant received 2 concurrent 12-month sentences, they serve 12 months total. Concurrent sentences are often appropriate when offences arise from same incident or transaction. Consecutive means run one after another. 2 consecutive 12 months mean 24 months total custody. Consecutive sentences are typically appropriate when offences are separate incidents or distinct type of offending. The totality principle requires stepping back after determining individual sentences and asking, is the overall sentence just and appropriate to the totality of offending? If the aggregate seems excessive, the court should adjust to achieve fairness. Court must explain why sentences are concurrent or consecutive. The reasoning matters because it demonstrates proper application of totality. Exam question can ask you, when are consecutive sentences appropriate? So you need to understand when offences are separate incidents or distinct offending types. At that point, the court will go for consecutive sentences. Next is suspended sentences and activation, and that's also sometimes tested in SQE. Suspended sentences occupy unique space between immediate custody and community sentences. Let's understand how they work. First, the court imposes custody of between 14 days and 2 years. This custody is then suspended, meaning the defendant does not go to prison immediately. Second, the suspension operates for a defined period called the operational period of between 6 and 24 months. That's what you need to keep in mind. During this period, the defendant must comply with any requirement imposed and must not commit further offense. So third, suspended sentences are not available for custody exceeding 2 years. If the appropriate sentence is above 2 years, it must be immediate custody. Fourth, if the defendant breaches requirement or confirms further offenses, like commits further offenses during the operational period, the court may activate the original custody. Activating is not automatic. The court retains discretion, but breach creates presumption towards activation. So fifth, activation means the original suspended sentence is implemented. The defendant goes to prison to serve the sentence initially imposed. So in exam, they can ask you, what is the operational period? The period during which the suspended sentence can be activated, ranging from 6 to 24 months. So breaches during this period trigger enforcement. That's pretty much simple. I hope you understand it. So the next thing that we got is non-custodial sentences and financial order. Community orders combine various requirements tailored to the individual defendant and offenses. The court can impose unpaid work requirement, supervision requirement, curfew monitored by electronic tagging, prohibited activity requirement, program requirement, and many others. All requirements must be proportionate to the offense seriousness. You cannot impose unduly burdensome requirement for relatively minor offending. The totality principle applies to requirements just as it applies to sentence. Financial orders include fines and compensation. Fines must reflect both the offense seriousness and defendant's means. The wealthy defendant pays more than a poor person like me. The fine should have equivalent impact. So compensation orders require defendant to pay victim for loss, damage, or injury. Critically, compensation takes priority over fines when the defendant has limited means. So compensating the victim matters more than punishing through fines. So discharges, conditional or absolute, represents the court decision that conviction alone suffices. Conditional discharge means the defendant receives no punishment unless they reoffend within a specified period. Absolute discharge means no further punishment at all. In exam, they can ask you, give 3 community sentences requirement for the list above: unpaid work, supervision, curfew, prohibited activity, program requirements, all of it. That is your answer for community sentences. So the next thing So let's turn to appeals, which provide mechanism for challenging conviction or sentences. From magistrate court to Crown Court, the defendant can appeal as of right against conviction or sentence. This is a full rehearing. The Crown Court hears the case again from scratch with a judge and 2 magistrates. Notice must be given usually within 21 days. So keep in mind the number 21 days. Importantly, the Crown Court on appeal can increase sentence as well as decrease it or confirm it. This risk must be explained to client considering appeal. Alternatively, either party can appeal by case stated to High Court. This route is only for points of law or jurisdiction, not disagreements about facts or sentence severity. The question posed must be a pure legal question. For Crown Court, after trial, the defendant can appeal to Court of Appeal, Criminal Division, against conviction or sentence. The test for conviction appeals is whether the conviction is unsafe. So leave to appeal is usually required, permission from the Court of Appeal itself. So the prosecution can appeal against unduly lenient sentences in certain circumstances, and there are other specialized appeal routes for them. So in exam, it can ask rehearing or point of law, like which route it should go. So rehearing is Crown Court appeal. Point of law is case stated to High Court at that point, and you should be able to distinguish between these two. Our favorite slide, SQE tips, and let's start. First, always start with the guideline, identify the offense, find the relevant guidelines, determine the offense range, and work through the steps systematically. Second, separate seriousness from personal mitigation. Assess culpability and harm first to establish seriousness, only then consider personal mitigation. Don't confuse these stages. Third, remember that bail status and previous convictions are statutory aggravating factors that increase seriousness. Check for these in every exam question scenario. Fourth, recognize Newton hearing, guilty plea, but disputed facts that would materially affect sentence, like at that point. The prosecution bears the burden of proving their version beyond reasonable doubt in Newton hearing. Fifth, understand the custody threshold test. The offense must be so serious that neither fine alone nor community sentence can be justified. The statutory language is key to understand and memorize. Six, no magistrate limit, 6 months per offence, 12 months aggregate for multiple either way offences. If a question involves magistrate exceeding these limits, that's wrong. So seventh, apply totality when multiple offences are sentenced. Justify why sentences should be concurrent or consecutive, and ensure the overall sentence remains proportionate. Eighth, remember Crown Court appeals can increase sentence. This is not just theoretical, it happens. The client must understand the risk. Ninth, case stated appeals are for law or jurisdiction only, not facts disputed or sentence severity challenges. 10th, Court of Appeal conviction appeals use the unsafe test. The conviction is unsafe in the light of the grounds raised. So this is the central question before Crown Court. So for exam, spot the correct appeal route quickly and try to understand that how it works, how appeals work, how sentencing works. I hope you understand it. If you like this video, hit the subscribe button and just send a text to your friend that I like these videos for preparing SQE1 exam. I wish you all the best. Ta-da!